I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Maryland is back at it. A couple of weeks ago, we reported that Maryland was on the verge of adopting a comprehensive state privacy law. That was signed. But they didn't stop there. In fact, the governor also signed a companion bill. This one focused on kids' privacy and protection of children online. To discuss that bill and what it means for your organization, I have invited back to the podcast a member of the privacy and cybersecurity team, Harsimar Dhanoa, to give us insight on what that bill includes and what does it mean for your company. Harsimar, welcome back to the podcast.
Thanks so much for having me back, Scott. Looks like Maryland's been busy at least the past few weeks.
Yeah, so let's just jump right into it. No need to kind of dive that bit into the larger privacy law, which the listeners can cover on the prior podcast. But let's learn a little bit more about the Maryland Kids Code and what that's going to mean for organizations who may be collecting data relating to children under 18.
Yeah, Scott. And I think the first step, one thing we should talk about is that normally when we talk about children or kids, we're thinking about COPPA and individuals who are under the age of 13. Maryland, like some of the other states that have passed or are considering an age-appropriate design code, has instead set the age threshold to be 18. So as a threshold matter, there's a lot bigger universe of people who are covered under this law. But generally speaking, what it requires is that businesses that meet certain thresholds, if their service is reasonably likely to be accessed by kids, then they need to take certain steps. And there are certain restrictions on how they're going to be able to use those children's data.
Interesting. So if I'm thinking about that, a couple of key notes. One is it's much broader than COPPA. And so organizations who may have thought about their compliance with respect to COPPA now need to do more. And second, it sounds like the application of these laws are going to apply to services that are reasonably likely to be accessed by children, which always is a difficult question, especially as different websites, different online services, different apps are become generally available and children may access them without the knowledge of the individual. So we're no longer talking about knowledge as being the standard. Now it's a reasonable likelihood that the service has been accessed by a child.
That's right. And I will say it even gets slightly trickier than that, because one of the thresholds is if a competitor service of yours is reasonably likely to be accessed by kids and they have a similar or the same type of service that you do, you can get pulled in as well. Not even because you actually know that there are children involved with your service, but because the marketplace is such that kids are likely to go to that type of service in general.
Really expansive then. I mean, especially as you think of teenagers and those who may be on the verge of adulthood, or at least on the verge of becoming 18, and they access probably all of the same oriented services as their adults in their lives. So what does it mean then if you have a service that's reasonably likely to be accessed by children? What are the substantive obligations that follow?
So I'd say that they fall under two big buckets. The first one are data protection impact assessments, where you have to look at your services, features, or offerings and really assess what the likelihood of harm to someone under the age of 18 is. There's a full list of factors that are in the bill itself, things like what is the likelihood of harmful contact to someone under the age of 18. And so there's a range of harms there that Maryland is trying to address. That's bucket one. Bucket two is a set of prohibitions on how companies can actually use the data of someone that is under the age of 18. So at a high sort of level, you can't process that personal data in a way that's inconsistent with the best interests of a child. And I want to pause there on that best interests of a child phrasing. We've seen that elsewhere in other age-appropriate design codes. Maryland actually helpfully is one of the few states that defines the term. And they're really focusing on, is there going to be physical or financial harm to a child, psychological harms, emotional harms? There is sort of a broad category around highly offensive intrusion on a child's reasonable expectation of privacy. So you can expect to see more discussion on what practices actually meet that threshold or don't. But generally, this is something that businesses are going to need to think about more is their processing in the best interest or not? There's also a more specific prohibition on using a child's personal data if it's not reasonably necessary to provide the online service or product that the child is actively and knowingly engaged with. And so this again is going to require some thinking around, okay, when someone who's under 18 comes to our site, what services are they actively and knowingly engaging with? Are there other services where we won't be able to use that data the same way? It's just going to require really thinking through all of your processing activities.
Yeah. And if I'm thinking through all of those processing activities, I heard you say, Star, that organizations now, at least for operating in Maryland, are going to have an obligation to conduct DPIAs or DPIA-oriented exercise. And then all of those limitations presumably would need to be documented inside of that DPIA about how is it that you are meeting those obligations. And to me, I think one of the key questions is going to become, so suppose I have a service that is reasonably likely to be accessed by a child. However, I have no ability of discerning whether any individual piece of information I get relates to a child versus one that relates to an adult, which typically creates a real challenge. Do I have to then use all of my data to go to the least common denominator to comply with this across the board? Do I have to collect more data in order to decipher who is an adult and who is not? Does Maryland speak to these issues?
So it's interesting that you mentioned that. On the first front of, do I offer my settings at the lowest common denominator? Maryland includes language about providing high privacy defaults. And so the expectation there may be, listen, even if you don't know this person's specific age, but you know that the service is reasonably likely to be accessed by children, you should be offering high privacy settings by default to all of your users. And that'll be interesting when we think about a year after the Kids Code comes online, the general comprehensive privacy law is going to come online. And so we need to think about how those settings will interplay with this requirement. But on the question around, is there an obligation to estimate a person's age or try to get additional information? So Maryland in particular actually removes some language around age estimation that was found in the original California age appropriate design code. And so we'll see if this ends up meaning that businesses feel more comfortable being able to, try to estimate age, even if there's no requirement, or if they feel like they're stuck in a position like that first set of circumstances where they just feel like they have to apply these settings across the board because they can't tell who is under 18 and who isn't.
The other point that you made, Harsimar, was around, I forget the phrase you used, like the best interest of the child. And in some ways, Maryland gave additional guidance about what that means compared to some of the other states that have been provided. But it's still rather a difficult standard to meet around trying to identify what the best interests are of the child, which typically in the US we would say is the responsibility of the parents or the adults in the lives of the individual. Is there a role for parents here, or is this something that now companies are the ones to decide the best interest of children?
So one of the pieces is around providing tools to parents to help them exercise certain choices that they want to make around what services their children might want to be able to access. Let's say, one of the privacy defaults prevents communicating with the public at large, and a parent says, no, that's fine for my child. Those parental tools need to be prominent and made available. But for the most part, it really is taking this sort of best interest of the child analysis and sort of moving it up into really, what a business has to think about might be in the best interest of a child, what the government might think is in the best interest of a child if there's enforcement, and then ultimately, a court if there's a disagreement between those two.
And if I conclude that something is not in the best interest of the child, does that apply to only data use and disclosure, or does it also apply to collection? In other words, if I'm an organization and I offer a website that collects information about users, do I need to make a decision about whether it is in the best interest of child to not collect this data at all?
So the language in the bill is processing, which includes use, disclosure and collection. And so I would think, yeah, you would have to start thinking about, does it even make sense to collect this data in the first place?
That would be a really difficult obligation to apply in practice. But as I think about it, it's not different than what we are hearing across the board from legislatures or from policymakers or regulators, that the role of data minimization is going to be a theme that continuously comes up and pops up in these laws and is a really challenging one. I've always kind of thought about things as more data, the better, right? Especially in the machine learning and AI world.
Yeah, Scott, that's right. It's part of a larger conversation around kids' safety online and whether their data should be subject to additional protections, how they navigate online spaces. Maryland's bill is part of a second wave of these age appropriate design codes. We started with California, that was first inspired by the UK. And when California's law was blocked by a district court judge as a content restriction that potentially violated the First Amendment, Maryland and a few other states took cues from that decision and decided to start making changes to try to address them and to hopefully pass constitutional muster. Candidly, I think it's likely that we'll see another legal challenge here. And so we'll have to see how Maryland's law fares under more scrutiny. But it's interesting to see this broader evolution of, there's a strong desire to do something to help address data processing practices and how children navigate these spaces. And this is sort of a direct outreach after that.
Yeah, I sympathize with the purpose and intent of kind of all of these statutes. I think, anyone with kids and who are concerned about how kids are using technologies, especially kind of early in their lives, I think the key issue is how is it that you're trying to address these harms in ways that are not going to interfere with, frankly, really valuable services that those kids love to receive and want. Harsimar, really appreciate your time and insight into this new Maryland law, and would love to have you back at some point to talk about how we see all of these age-oriented laws and these age design codes, are how we're seeing them play out over the entire country and perhaps even in Europe.
Yeah, Scott, thanks again for having me. And I expect that we'll be back together soon. Maryland wasn't the first, and I'm sure it won't be the last on this front.
Yeah. Well, with that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.